The Supreme Court just kicked off what might end up being the most important conversation of 2026. Let me tell you why I think it's going to end poorly for Trump. The headline is that the Supreme Court denied a request from the Trump administration to overturn a lower court's ruling that blocked the National Guard deployment to Chicago. Now, critically, the ruling was 6-3 in favor of Illinois, and we'll get back to that in a minute. But essentially, it shuts down Trump's invasion of Chicago and really every other city outside of D.C. In the 6-3 majority ruling, 5 justices agreed with one opinion, with Kavanaugh writing his own narrower concurring opinion, joined by nobody, and we'll come back to that too. Now, this ruling related to the specific wording in a statute Trump tried to use to federalize the National Guard. That statute said the president can only federalize the Guard if regular forces are insufficient. The Supreme Court determined that regular forces meant the military. And since the military can't be used to enforce civilian law because of the Posse Comitatus Act, the court determined it would be logically impossible for the president to have the power under that statute without invoking another act first. That act, of course, is the Insurrection Act. So now the question becomes, will he invoke it? And more importantly, if he does, what will the courts do? Which brings me back to this 6-3 decision and Kavanaugh's sole concurring opinion. Because in this decision, 5 justices, including John Roberts and Amy Coney Barrett, agreed with the 3 liberal justices and in the process held the federal government to an exceedingly high standard as they denied federalization of the National Guard. More importantly, none of those 5 justices felt the need to agree with Kavanaugh. And it was Kavanaugh's opinion that specifically called out the Insurrection Act to protect it. For me, the implication here is that those 5 justices would apply at least the same level of scrutiny in the event Trump tries to invoke. Because we're not talking about Clarence Thomas and Samuel Alito here. We're talking about the 2 most moderate justices. And we're talking about ruling on an act that is significantly more consequential. But that doesn't mean Trump won't try to invoke it anyway. So let's talk about what would happen if he does. Invocation against the permission of the state requires one of 2 things to be true. First, because enforcement of civilian law is impossible because law enforcement is overwhelmed or civilian courts no longer function. Or second, because there is an insurrection that is so serious it is depriving people of their constitutional rights. Now, it's true the president doesn't need permission from Congress or the courts to invoke, but invocation is the beginning of the conversation, not the end. Because first, the moment an invocation is made, Trump would have to issue a formal declaration demanding that the insurrectionists disperse. And then at that point, only if they did not, could the military or the National Guard come in and enforce civilian law through the civilian justice system. But I don't even think we'll get to this point, because first, this 6-3 decision is not final. So the Trump administration will most likely let it play out at lower courts, with hopes it'll reach the Supreme Court on merit alone, before they have to play their final card. But also because if he did try to invoke, the state in question, which would undoubtedly be a blue state, would instantly file a lawsuit seeking an injunction. And because it would be a blue state, they would probably be able to find a federal judge who would grant it. So then you have a lawsuit playing out across the midterms, forcing every Republican member of Congress to decide if they're going to stand with the people or Trump. And he's not on the ballot. But even if he does invoke and it gets appealed to the Supreme Court, once it did, the case would be heavily in favor of the state. Because the Insurrection Act is ancient and poorly written, and it has never before been tested like this. Because the last time it was invoked without permission from the state was in the 60s in the South. And that one actually tracked because you could prove in broad daylight that citizens' rights were being deprived. Meanwhile, this case is the exact opposite. States don't want it, and the conditions on the ground don't warrant it. And in this case, the only reason the justice system is strained is because of Trump's deportation quotas. Meanwhile, the only rights being deprived are the rights of the people the Trump administration is trying to detain. Because remember, the Insurrection Act was written to protect our rights, not empower the federal government, ultimately setting the Supreme Court to have to decide between the Trump administration, the intent of the Insurrection Act itself, and the 10th Amendment, which explicitly reserves all powers to the states that are not specifically given to the presidency by the Constitution. The court would have to decide if the conditions on the ground meet the conditions specified in the act, which they do not, and if the act needs to be further narrowed and defined to protect Americans from authoritarian abuse, either from Trump or from future Democratic presidents, which it absolutely does. Now, stepping all the way back, we are talking about a very fragile house of cards supporting Trump's final card to play in his battle with blue states. And if he does try to play that final Trump card, I think what we'll see is that just like everything else with Trump's name on it, once we clear the smoke and shatter the mirrors, the whole charade will be exposed as a hollow failure. Just like him.